I've got a pension worth 100 grand, he's got 200 grand. Well, some of that was only contributed during the marriage and half of it wasn't.
Okay, so
the Cafcass report is recommending overnight stays every weekend. For me, there's many flaws within this Section 7 report.
These children should have a relationship with both of you.
I have no pensions, I have no savings, I have debt. My husband said that, look, you aren't well enough. I can financially look after the both of us.
Right now, I'm seeing somebody who's vulnerable and is definitely going to get a decent financial settlement. So what is it that you're afraid of? Welcome everyone to the Legal Queen live show. I am your host, Tracy Maloney, aka the Legal Queen. I am a practicing family law solicitor and have been now for over 20 years. During that time, I've helped thousands of people with their family law issues and questions, divorce, finance, children's matters. If you have a family law issue that you think I could help you with, then by all means, join me on the Legal Queen Discord. Come into the Legal Queen Lounge, pop your hand up, and I'll get to you as soon as I can.
Hi Tracy, yeah, it's kind of around pensions, just with you mentioning a bit about that then.
Yes.
So I believe it's contributions during the marriage.
Yes.
We're going to have a pension actuary report done because we've both got quite significant pensions.
Yes.
But my question is, if it comes out, say for argument's sake, I've got a pension worth 100 grand, he's got 200 grand. Is the idea that they offset 50 grand of his so that we both come out with 150? Is that how they look at it? Or do they go into the depth of, well, some of that was only contributed during the marriage and half of it wasn't?
Okay. So, yes is the answer to the first question, but let me just give an explanation. So the first thing we're looking at are the contributions made during the marriage. So if either one of you or maybe both of you are saying, well, hang on a minute, I paid into my pension for 5 years before I got married, then the actuary will look to ring fence that for you and for him. Okay. Sometimes clients will say to me, particularly if it's a long marriage, if it's a 30 or 40 year marriage, well, I was paying into the pension, but for only 2 years before I got married. My advice could then be, look, it's not worth paying an actuary to ring fence those early 2 years when maybe you were 25, because it wouldn't have been a lot of contributions anyway. So that's the first thing I would say. Let's look at how many years we are looking to ring fence to see if it's reasonable to do so. But then you're right. So if we then have a conclusion that during the marriage you paid in 100 and he paid in 200, we have £300,000 worth of pension to divide between you both, which means you both get 150. You've already got 100, so you're going to have 50 grand from his pot, just to use your example figures, which would be, 25% of his pension. So the pension order is then worded that you're getting 25% of his pension. And then once the divorce is pronounced, everything after that is completely separate. Obviously, you're not entitled to that. The pension share is done at the time of the divorce. So they're lifting out 25%, this year, so that he can then go on to pay into his pension pot knowing that it's safe.
And sorry, just a follow-on question from that.
Yeah.
So one of his pensions he is actually drawing down at the moment. So that's kind of income he's receiving now.
Yes.
And that tops up his earnings.
Yes.
Now I'm the bigger earner.
Yeah.
Will that impact me being entitled to X of his pension because he's topping up his income now with that?
Well, it definitely will, because if you think about it, he is drawing down on a pension of which you are entitled to a share. Now, that's where the extent of my knowledge stops and where we have to get an actuary in, because then the actuaries are able to do the equations whereby they can tell us what percentage you are to receive to allow for the fact that he's been drawing down. So sometimes I'll get a client that says, especially if it's a long marriage and maybe we're already in retirement, and they say, well, my ex has been drawing down his pension for the last 10 years. Well, we have to account for that. But the actuary will help us with that. Yes is the answer to your question. I just wouldn't know what the equation was there, because that's very specific then to the pension actuary.
Hiya.
Hello.
So we're just in the early stages of the divorce. So we've done it ourselves and submitted it to the court, and we're in the 22-week period where we're calling off.
Yes.
So I'm trying to get the financial order sorted, but we're kind of coming into loggerheads. We don't have a lot to sort out, so we don't have any property or anything like that. We just have a pension.
Yeah.
I've got a pension through my company, and she has probably a small one. I don't know what size it is, but that's literally probably the only thing we need to sort out, apart from the fact that she wants some type of what do you call it?
Spousal maintenance?
Yeah, spousal maintenance.
Yeah.
That's it. Yeah, so she's asking for spousal maintenance, but we co-parent, so we don't do any CMS or anything like that. We have 50-50 of bringing up the kids, so we don't have any CMS or anything like that. But basically, I'm trying to book a MyAMS to try and amicably sort it all out.
Yeah.
But she's kind of dragging her heels and not wanting to give me a date or a company we could go to do a MyAMS.
Yeah.
To try and hash it all out. So what's kind of my next steps? Because I don't think we've got very long. We've got probably like a month until the 22 weeks is over. I think it's like the 22nd of this month that the calling off period ends. So are we running out of time? What should I sort of do?
No, I think that the next stage, it's 20 weeks. Once the 20 weeks are up, you can apply for your conditional order, okay? 6 weeks after that, you can then apply for your final order. So then the divorce process is complete. It's in between the conditional order and the final order, so in that 6-week period, that we submit the financial order, okay? But what I would say to you, Lewis, is don't panic about the timeline, because once you've got your conditional order, which we need, by the way, we can't submit the financial order to the court without that. But once you've got that, there is no rush to apply for your final order, unless, of course, one of you are looking to remarry again. So you can push that final order out as much as you need to. You know,
okay, so there is a grace period between those 2 days.
Absolutely.
Oh,
So
good.
some of my clients have had their conditional order for 2 years because, you know, we end up going to court to sort out the finances. And so we're not applying for that final order in divorce. So you can take as long as you need to. But to go back to your original question, what do you do if she's sort of stalling and not really wanting to go to mediation? As I say all the time, mediation is voluntary. It's not compulsory. I think her actions would suggest to me that she doesn't want to do it, because if somebody wants to do mediation and they want to engage and they want to bring about a resolve, you know, it's not too hard to say, fine, give me a couple of weeks to get some advice and get all my documents together and then book it in any time after that. She clearly doesn't want to do it, or she's dragging her feet, whatever. So the only resolve for you then, which is unfortunate, is that you'll have to make a court application. Because by making the court application, you then have your timeline in place. You know, finances will only consist of 3 hearings. They can settle at any time, but they will only have 3 hearings. And if you two haven't agreed or settled at hearing number 1 and number 2, judge is going to call it at hearing number 3. So for a lot of people where potentially they're in solicitors negotiation or mediation's going nowhere, my suggestion is always make the court application, because otherwise you could still be, you know, going nowhere in 12 months' time. And it's a shame if you've got nothing to sort out, only a pension and potentially spousal maintenance. But, you know, I've got clients that are going to court for a clean break order, as ridiculous as that sounds, because the other side just won't respond to my letters. You know,
Right.
they just won't sign it. So there we go.
Yeah, it's probably a very small pension as well, and
Yeah.
by the time the solicitor fees are probably both sides done, the pension would probably be soaked up
But-
within the cost anyway. It just doesn't
But then
make a lot of sense.
But then what I would say, Lewis, is you don't need to get solicitors. Like for those clients of mine that are trying to get a clean break order, all I'm doing is helping them draft the application. That's it. I'm not suggesting that I continue on the process with them, because why would I? As you say, there is nothing, they're not going to get anything out of it except for that clean break order. So do it yourself. It's very straightforward where we've got no finances involved.
But it wouldn't be a clean break order if we're sharing, if I
No,
give
no.
her 50% of my pension.
No, absolutely. But even so, it's just going to be a pension share and thereafter a clean break. So, we don't need, that's not complicated, because what happens is when the order's made, the pension share order is then sent to your pension provider. They are going to lift 50% of your pension out of your pension pot and pop it into her pension pot. So the legal argument that's involved in that is, well, there isn't one, is there? And that's why you don't need a
spousal
solicitor.
maintenance would be an argument, because I don't believe I should be paying spousal maintenance.
It would be, but again, I would be suggesting that you seek a 1-hour advice to find out, actually, does she qualify for spousal maintenance, and how you defend a spousal maintenance application. And then again, you can make that yourself, as opposed to having a solicitor on board to do everything for you.
Right. Okay.
All right.
That's handy. So is there any kind of guidance on how to do it yourself then, in terms of doing the pension share order and doing all of that?
So there'll be lots of notes online. I have done a course on just this. I've done 3 courses actually, divorce, finance and children, about how to represent yourself. And I show you all the forms that you need to fill out. I take you all the way through to a contested hearing. So have a look at that. You'll find that on my website. There'll be notes with regard to filling out the forms on the government website. And then, as I say, I think the best thing that you could possibly do is just get that 1-hour advice. Once you've made the application, just get a one-off consultation, whether it be with me or with somebody else. And, a lot of times I'm just using that consultation with people to just talk them through how they do it themselves and what to expect.
Okay.
All right.
When you do split the pension,
Yeah.
I've got like a work contribution, so whatever I put in, they put in more.
Yeah.
When they split it, is it what you physically contributed, or do they get part of the contribution from your company as well?
Yeah, it's all of the contributions, all of them.
Okay.
And the reason for that is, let's imagine for a second that the marriage didn't end in divorce, and made it to retirement age. Or at retirement, your spouse would have benefited from all of the contributions. It wouldn't be a case of, well, because my employer contributed, you're only going to get what I contributed. So it will be all contributions made during the marriage, yeah.
Okay, cool.
Yeah.
Yeah, that's kind of what I wanted to know, because someone else gave me some advice and said, no, it's only what you've contributed, not what your business have contributed.
No, it'll be all contributions. And equally, any contributions that she has made as well. It's not just going to be looking at yours. I accept, because I know you were on earlier, that you have the bigger of the 2 pensions, but we are looking at all contributions made by both parties, no matter how small they are. And of course, her entitlement to any of your pension will be impacted by any pension she already has.
Mm-hmm.
All right.
And the second question about debt. So we had about £10,000 worth of debt when we split, but we've only just recently gone, so we've been split for 2 years.
Yeah.
And I cleared all of that debt when I left, because I moved in with my parents.
Yeah.
And I cleared all of that debt, because that debt's all cleared now and technically debt free.
Yeah.
Then does that not kind of sort of come into contribution towards the financial order?
Yeah, so you mean, will I get an adjustment for having paid half the debt off? All the debt, but half of it was hers. I suppose the first question is, can we show that it was matrimonial debt? If it was matrimonial debt, then yes, you were both responsible equally for that. But then we would look at earning and income capacity. So her argument could then be, yes, well, but I wasn't earning, so I couldn't pay the debt off. So the adjustment will depend on those 2 questions, or the answers to those 2 questions. But it's definitely worth throwing onto the table, because it's a consideration that the court will definitely take into account. It might not get you anywhere, because I don't know what you're earning and what she's earning, and please don't tell me. But you know what I mean? It might not get you anywhere, but definitely worth throwing out there, Lewis, for sure.
I personally didn't really want to. I said it as like a mention when we discussed about other things of splitting stuff, but I to be honest, because I was in a position where I moved in with my parents, I could clear it, so I was just like, do you know what, don't worry about it. But it was just in the back of my mind, when you're going after spousal maintenance and you cleared £10,000 worth of debt, it's kind of like, You know, would you not
Absolutely.
just
Absolutely.
like
I mean,
the small little things?
yeah, I say this to all of my clients. You've got to approach divorce as a business transaction. There is no malice intended. You know, we're not being bitter and we're not trying to get back. We are simply looking at it as a business transaction, because divorce is always about the future. Always about the future. So you have to sit down and be very pragmatic when it comes to the finances. You know, and try to get it as black and white as you possibly can. Yes, of course, there has to be an element of fairness, but that works both ways. You know, it may not be fair that you paid all of the debt and then you have to pay spousal maintenance and then you have to give half of your pension. That may then be too much, you know, in her favour. I can't answer that without giving, you know, having an appointment with you and giving you some proper advice. But you're absolutely right. You've got to look at it in that pragmatic way.
Quick one for you. Married, currently in separation, living apart. Do I have rights to access my home? For example, every evening for a couple of hours. I am the homeowner. My wife isn't communicating. Just something reasonable for a couple of hours each evening with the children. Thanks.
Look, the legal answer is it's his home, absolutely. But in reality, we don't recommend that. If you've separated, then you've gone. And I think a better alternative would be to collect the children and spend a couple of hours with them elsewhere, simply because it's awkward for the parties. You know, you have separated and now you're back in the house, and, you know, maybe you're making yourself a cup of tea in the kitchen, but you've been gone for 12 months. That's all just very awkward, isn't it? It's also a little bit confusing for the children. Because you could find yourself in a situation where the kids are going, well, just stay over, Dad. You know, you don't have to go. You can sleep in my bed, or, you know. So my suggestion would be to collect the children and have contact with them outside of the home. And yes, it's tricky because it is still his home and his name is still on the property. But again, as I said earlier, it's a consequence of separation. I would afford my ex the courtesy of just not doing it until the divorce was sorted.
Split with the ex in February. He's a director of 3 businesses and took over 100,000 in dividends in the last tax year. We were together for 13 years, still living with my mum and children in a 1-bed bungalow, and I can't afford to do anything about it. Anything advice? So she basically split. Husband's still in the home.
Yeah.
From what was she entitled to?
Okay, definitely she's got to get some advice, because we've got a big earner there. You know, if husband is earning more than 100,000, whether it be in dividends or whatever, then, you know, the court would expect him to be helping her financially and helping the children financially with their housing needs until such times as we've got that financial and final order in place. The fact that her and the children have to live in the mother's property, you know, away from their home and what they're used to, and she can't afford to move out, tells me that there's a bit of an imbalance there. So I would definitely be saying, get some advice and get it sooner rather than later, because spousal maintenance is based on need. If you leave it a few months, you make proving that need harder. If you jump on it as soon as you separate, it's so much easier. And look, I'd want to know, you know, if I'm going through a divorce and I am the financially vulnerable, in other words, I maybe haven't worked or only work part-time, I want to know, you know, what does my future hold? What am I entitled to financially? So for that particular lady, I would say get some advice. It's priority, even if it's just a one-off advice.
I have a question about the family court process.
Yes.
So a little bit of background. Social services actually put a no contact order in place with the father due to safeguarding concerns.
Yes.
The father then took it to family court. A Section 7 report was done, which has so many flaws in it. For example, my children are very, very young. They're 10 months and 2. And the Cafcass report is recommending overnight stays every weekend. as of August, but he has no fixed abode. He works night shifts on the weekends and doesn't work during the week. So for me, there's many flaws within this Section 7 report. The court did ask Cafcass for an addendum report, which we will get at the next hearing, but we don't get the report until a day or two before it goes into court. I'm not saying he can't have no contact at all. I'm just saying I don't deem this safe or appropriate. He hasn't done the things the court have ordered him to do. So I'm saying I feel a couple of hours multiple times a week would be more appropriate at their ages, given the safeguarding concerns, as opposed to all weekend, every weekend. Am I allowed to sit in the courtroom if I feel that the safeguarding risks haven't been reduced and say no,
Well,
as the
yes.
parent with PA?
Yes, because that's your case, isn't it?
Right.
You can't just say no. You've got to make out your case.
Oh, yeah.
So
Yes.
so your case is that whilst Cafcass have made recommendations, you don't feel that they are appropriate. You're going to have to build your case around why they're not appropriate, why
Right.
you don't feel that they should have overnight contact. And, you're going to have to put forward a strong case. Remember that the court's starting point is that these children should have a relationship with both of you.
Oh,
So
yes, and I agree with
you
that. I just feel it needs to be safe and well managed,
absolutely. So but you have to remember that the court's not going to be making the decision based on your standard of safe. Okay, so where I sometimes feel that people maybe lose their cases, and I'm talking about children's cases, is that Cafcass will make a recommendation, as in your case, that fathers should have some overnight contact. They then didn't find any safeguarding concerns that they would feel would prevent that. You are saying, well, I do have safeguarding concerns. And therein lies the conflict, because your concerns may not be shared by the court, and they're clearly not shared by Cafcass. So if you are going to mount that argument, make sure it's really strong. Make sure you've got cast iron examples that are going to convince the court to completely ignore Cafcass's recommendations. That's not an easy task, Hayley.
The case that I'm currently building is based upon the fact that he has no fixed abode, works night shifts during the hours that Cafcass have recommended he has them. Also, during the contact centre time, it's been documented that he has only fed one of the two children every single time. And the child that he hasn't fed has severe allergies and is under a strict dietary plan due to growth. So the hospital have said it's actually medical neglect at this point, and that has been documented. Are these leads sort of strong enough for me to be going with?
I think the only strong one there would be a letter from the hospital to say that it was medical neglect. The fact that he works shifts and has no fixed abode, it isn't.
Okay, lovely, thank you.
The dad has got no contact. He is paying child maintenance.
Yeah.
I think she's pointing towards that because he pays child maintenance, that he has an automatic right to the child.
Yes.
So what can they do?
Well, it doesn't work like that. So you are always going to be liable for child maintenance, but that doesn't give you an automatic right to having contact for obvious reasons. We might have safeguarding concerns. So what I would suggest is that you pay your child maintenance, and if your ex is preventing you from having contact with the child, then you might want to think about mediation or making a court application. So, one isn't dependent upon the other. You can't just assume you're going to get contact because you pay your child maintenance. And equally, there are fathers out there that maybe aren't working, that don't pay child maintenance because they're on the zero allowance, but they're having contact. So it works both ways.
My partner has a child with an ex who doesn't allow him to see her only on her terms.
Yes.
Maybe it's once or twice a month for a couple of hours with only a couple of hours notice.
Yes.
She tells him all the time she cannot see her until he does this and he does that. Usually pay for nursery fees, which she gets money from the government to do so. There is no court order and nothing in place.
Yeah.
She often keeps saying that she's going to wait for a letter from the court with his application. What can he do? But the courts, I don't think he can afford to go to court.
Okay. So there's a couple of things there that I would say. That's really bad co-parenting. It's the child's right to have a relationship with both parents. So unless you have safeguarding issues, please don't stop the child from having a relationship with the other parent. If she simply is not willing to allow contact and she has said that I'm waiting for the court order, he's going to have to make the court order. If money is an object, and it is, sorry, if money is an issue, not an object, if money is an issue, and it is for a lot of people, I absolutely get it, then he will just have to represent himself, in which case it will cost him nothing, save for the court fee. So he downloads the C100 form, he fills it in, and he sends it to court. The court fee for a children's application is around the 260, I think it's £263. If he's on low income or on benefits, he could complete the EX160 form, which may get him a court remission. In other words, he doesn't have to pay the court fees. And thereafter the court fee, there is nothing further for him to pay if he doesn't get a solicitor. So when people say to me, I can't afford to make the application, your only hurdle is the court fee if you are representing yourself. So give that some thought. But yes, I mean, clearly this mum isn't, conducive to allowing a relationship, and that is definitely not in the child's best interest. So I think he should get to court quick smart.
I moved in with before I married him in 2010.
Yeah.
And we separated, I left in October 23.
Yeah.
Because there was a lot of issues to do with control and abuse and stuff. So
take your time, Z. I can hear that you're getting it. Yeah, take your time.
I moved 4 times in 4 months because I know other people can hear this, but I was serious. The word beginning with R.
Yeah.
I was by a police officer in 2008. And I never told anybody. I never told my husband when I married him. I never told my family. And then the police contacted me after we'd got married. But this is obviously that's not to do with this.
Yeah.
But I left him because I'd been going to therapy, and obviously I came out and told them about what my husband had done to me.
Yeah.
To do with abuse.
Yeah.
And they said to me, "Are you afraid of him?" I said, "Not anymore." They said it, well, not in that way, but they said, "Are you afraid he'll do something to you?" I said, "I've gone beyond that stage."
Yeah.
I said, "I've gone beyond it as to, I think you need to be thinking about what would happen to him."
Yes.
I said, because I'm at the point now where I can't take it anymore. So they said, right, we'll move you. So he was away in Devon and the council moved me straight away. I moved 4 times in 4 months.
Yeah.
And now I'm here in a 1-bedroomed bungalow. And he has the big 3-bedroom bungalow with all the land and everything.
Z, how is it? How is it I can help?
I put in for the divorce.
Yes.
The financial agreement is a bit of a mess because obviously we've got the conditional order that came through in April.
Yeah.
But the financial order, Tracy, is I have no pensions.
Yes.
I have no savings. I have debt.
Yes.
But the one big thing why I got myself into debt is when we was married,
Yeah,
and we still are obviously, but I used to get an allowance every month.
sure.
And when my daughter went to university, but that allowance stopped, and we gave her the money to, because she's autistic, we gave her the money so she could do a course, and she needed materials for a course.
Yes.
And
So,
then it was agreed.
sorry, Z.
It was agreed that
Sorry to interrupt you.
it was agreed.
So are you saying that you don't have a financial order yet?
No,
Okay, so,
no, because
that's good. But let me just jump in. I don't need to know why you don't have one. What I'm saying to you is that's good, because I don't want you to share too much on this public forum, but I can tell from the very limited information that you've given me that you definitely have a financial need. Okay, it's something that I want to pick up with you offline. If I could ask you to email me, then you and I can have a very private conversation. But I get where you need help. You need a financial order because you need financial help. I absolutely get that part, and that is definitely doable. What is it that you're worried about with regard to getting the financial order, or maybe you're not? I don't know.
I am worried
Why?
of how it would all go, Tracy, because I have got disabilities. I
Yes.
had a serious head injury when I was 16, and in 2009 I was diagnosed with bipolar because of that head injury.
Yes.
So I have my physical needs as well. I
Yes.
am on PIP, and I haven't worked because my husband said that, look, you aren't well enough.
Yes.
I have enough money coming in. His job it gets paid a hell of a lot amount of money. He said, I can financially look after the both of us.
Yes.
And obviously then he didn't give me the money back after our daughter stopped university. So
Okay.
all the debt that I have got.
Let me jump in again, Z. I totally get it. He's been very unfair and unreasonable. But you, from what you've said, you have some disabilities. Absolutely, I understand that. You would be described within a family law context as being financially vulnerable, okay? Which means that you are the weaker party financially. And the court, remember, are going to make a fair and reasonable financial order. So already there's a big chance that we're going to be moving away from 50-50. So let me ask you again, what is it that you are scared about in getting the financial order? Because right now I'm seeing somebody who's vulnerable. I'm hearing someone that's vulnerable financially and is definitely going to get a decent financial settlement. So what is it that you're afraid of?
He won't do it. He'll end up.
Okay.
I've got a feeling he'll end up hiding stuff.
Okay, that's fine. I hear you. I hear you. That there is a level of intimidation sometimes that can go unrecognised when we are seeking legal help. All I would say to you, Z, is definitely email me off air, because I will definitely be able to help you. Okay, we can't go through life when we finish a divorce that's been particularly unpleasant in your case with that intimidation hanging over our head. There are lots and lots of things that we can put in place by way of protection. And I hear what you're saying about the constant moving every month for 4 months. I hear that, but there are remedies in place. So if you email me offline, we'll be able to pick this up. Can you just remind me, because I do get over 100 emails every day without fail, which I don't mind at all, but just let me know, because obviously your name on your email might be different to what you're calling yourself on Discord, that you and I chatted on Discord, just to refresh my memory, okay?
Yeah,
Lovely.
I will do, Ducky. Yeah,
all right,
you.
No problem. I'll speak to you soon, Z. Take care.
Speak to you soon, Ducky. Thanks.
Bye-bye.
Bye-bye.
Guys, for anybody out there, that was a very distressed lady who is going through a divorce, as a lot of you are when you're speaking to me. but there was an underlying bully, intimidation, stuff going on there, coercive control, call it what you will. We can put any label we like on it. But the real reason that we weren't moving forward is because of fear, you know, and I get that. I absolutely get that. But please know that there are remedies that we can put in place that will afford protection. We don't have to disclose our address, for example. You know, we can get an injunction to stop both direct and indirect contact via legal aid. We might not be able to get the divorce and the finance through legal aid, but we can definitely get an injunction through legal aid. We can have a legal aid solicitor and a private solicitor, which is what I am, working on your case at the same time. That's absolutely fine. The thing to do is always, like Z just has there, reach out and ask the question, because you don't know what you don't know, okay? And it's much better to ask the question than live in fear. So thank you, Z, for sharing that. I get that that's incredibly painful for you, and I do appreciate it when people come on and share their very personal and sensitive issues with me. Because if nothing else, Z, you have well helped another vulnerable person, okay? And I can see that you're getting lots of comments flooding through by way of support.